Chapter 37, Married Women, Section 1366 and 1367, Disabilities of Married Women at Law. We may next proceed to the consideration of the peculiar jurisdiction exercised by courts of equity in regard to persons and property of married women, and principally in regard to their property. It is not our design in these commentaries to enter upon any consideration in the general doctrines relative to the rights, duties, powers, and interests of husband and wife, which are recognized at the common law. That would properly belong to a treatise of a very different nature. It would be sufficient for our present purpose to examine those particulars only which are peculiar to courts of equity, or in which a remedial justice is applied by them beyond or unknown to the common law. Although these doctrines are for the most part rendered obsolete by the operation of the Married Women's Property Act of 1882, from their historical importance it is considered advisable to retain them in the text. It is well known at the common law husband and wife are treated for most purposes as one person. That is to say, the very being or legal existence of the woman as a distinct person is suspended during the marriage, or at least is incorporated and consolidated with that of her husband. Upon this principle of the union of person in husband and wife depend almost all the legal rights, duties, and disabilities which either of them acquire by or during the marriage. For this reason, a man cannot grant anything to his wife or enter into any covenant with her, for the grant would be to suppose her to possess a distinct or separate existence. And therefore, it is also generally true that contracts made between husband and wife when single are avoided by the intermarriage. Upon the same ground it is, that if the wife be injured in her person or property during the marriage, she can bring no action for redress without the concurrence of her husband. Neither can she be sued without making her husband also a party in the case. All this is very different in the civil law, where the husband and wife are considered as two distinct persons and may have separate estates, contracts, debts, injuries, and may also, by agreement with each other, have the community of interest in the nature of a partnership.